Hi, this is Martha. Today we're going to describe what a trust is. Trusts are really interesting vehicles for property ownership and for family governance. And when I first did my own estate plan when my first child was a baby, I hired a family friend. My ex-husband and I hired a family friend to do our estate plan. And he provided us with an instrument called a revocable living trust. And I had no idea what it was. And I asked him, and I kind of nagged him, and I said, can you please tell me what this is? I don't understand it. This is really strange. How do I manage it? How do I approach it? And he actually got a little irritated with me because I couldn't seem to understand it. But now I do. I had to go to law school. I had to do this work and really work with different ways of explaining what trusts are. So I understand why there's confusion over what a trust is. So I'm going to take a couple of cracks at it, and with the three or four different ways I'll describe it, when we put them together, we get a nice idea of what a trust is. So a first rule is that we own property in our own human hands. Our hands are made of flesh and bone, and they're mortal, and they're fallible. And whenever we own property in our own hands, it's subject to our own mortality. So if we have a disability or we die, what we own is sort of left without any owner. And that's actually just a flaw of ownership. A trust is something that can kind of come in out and underneath our mortality and own stuff for us in a way that is owned by an immortal entity. A trust is, in theory, it's not fully immortal, but it certainly is more immortal than we are. So the first way to think about it is that it's a contract. It's a very complex contract, not to be drafted by a computer system or by someone who only does trust work on occasion. It's very complex, so it's not the kind of thing to just let just anybody do. As a contract, it's actually called a split of title. So when we are a grantor of a trust, we're the creator or the settler of a trust. We are agreeing with another person, which actually can be ourselves. We are agreeing that we are going to give them the legal title of what we own. And under the contract that we sign with them, we say, you're going to own my property, but you can't use it for yourself any way you want. You have to use it for my beneficiaries, these other folks over here, in the way that we are going to agree to in writing. And the beneficiaries over here have the beneficial title. So the trustee owns the legal title. The beneficiaries own the beneficial title, or a beneficial interest in the trust. So it's actually, when we do a revocable living trust, a three-party contract: the grantor, the trustee, and the beneficiaries. Strangely, in the revocable living trust arena, when we create one for our clients are all three parties to begin with. They are the grantor, the trustee, and the beneficiaries, and they can do whatever they want with their trust. When they're disabled or they die, then we have substitute trustees. And if they've died, we probably have substitute beneficiaries. So we now have a very live contract among two parties. The grantor is now out of the picture, and we have a trustee and a new beneficiary, and we're off to the races. So we think of it as a split of title in one way. And another way, we think of it as a contract that we're creating with ourselves for the benefit of ourselves, with people to come in after us as our successor trustees and our successor beneficiaries. Another way to think of a trust is as a vehicle. It is something that we can take from our mortal hands that are made of flesh and bone, that can be disabled and that can die. And we put it into, I call it a little red wagon. So we put our stuff into a little red wagon and we carry the wagon. The wagon itself is immortal. It has a name, it has a birth date, it has a personhood of a sense, and it can hold title to things. Now we've created that little red wagon out of paper. Just the minute you sign it, we boom, create it, which is really the hard part to understand. We create an instrument or a vehicle out of paper. We don't register it anywhere. We don't have to tell the Secretary of State about it. It's kind of remarkable. You just sign a paper and boom, there it exists. So a revocable living trust is the most common type of a trust. It is revocable, amendable, changeable by the grantor, the person who creates it. And it's a very helpful vehicle for seamless family governance. when there is death or disability, when we start losing our marbles or having early onset dementia or start slipping, or we slip and we fall and we die. It's a way that we can move that little red wagon to our family in a very seamless and easy way and keep it out of the court system and make sure that the person that we want to manage our stuff in our little red wagon is in charge of that, using it the way we want them to use it for our families. So hopefully that'll help clear up a little bit of confusion about what a trust is. So just to recap, it's like a contract between the grantor, trustee, and beneficiary. It's a split of title between the trustee and the beneficiary. The trustee owns the legal title, the beneficiary owns the beneficial title. And it's a vehicle with which we can move our assets through our lives without ever having to get a court involved. It helps to prevent court intervention in our family lives. So hopefully that helps. Talk to you later.